appeal, W.M. Morrison Supermarkets plc and various claimants.
Good morning, my lady, my lords. I appear with Anya Proops, Rupert Paynes and Gayatri Sarathi for the appellant Morrisons. Jonathan Barnes and Victoria Jolliffe appear for the respondent claimants. The court will have seen the extraordinary background to this appeal. Because of a grudge against Morrisons and in order to damage Morrisons, the company's employee, Andrew Skelton, disclosed on the internet the payroll and other personal data relating to just short of 100,000 of Morrison's employees. And he was sentenced to 8 years imprisonment for those criminal acts. He remains in prison. I understand his release date is now next January 2020. There are two main issues on this appeal. The first is whether Morrisons is vicariously liable for the wrongful acts of Mr. Skelton in copying and then disclosing that personal information. And if the answer to that first question is in the affirmative, the second question is whether the Data Protection Act excludes vicarious liability, both under that Act and at common law and in equity. The claims are for alleged distress, anxiety, upset and damage. None of the claimants contends that he or she suffered any financial loss.
I understand that Morrison's also took steps to sort things out for them so that there wasn't
That's
any
why they
further
didn't suffer any financial loss.
Yes.
Your Ladyship will have seen that what happened was that the newspapers to whom Mr. Skelton disclosed the information acted very responsibly, informed Morrisons, who immediately took steps which were effective, albeit expensive, to ensure that none of this material remained accessible for any longer period than was absolutely necessary, and therefore none of the employees happily suffered any financial loss. They claim for, as I shall show the court in a few moments, they claim for the distress that they say they suffered as a result, the anxiety, upset, distress that they suffered as a result of knowing that this material had been disclosed in the way that it was. At trial before Mr. Justice Langstaff, the judge rejected the claimant's argument that Morrisons had primary liability, whether under the DPA or at common law or in equity. The judge's conclusions, which are not in dispute, are at paragraphs 123 to 125 of his Lordship's judgment, which is MS page 258, but I won't take time on that unless the court wants me to. What the judge did find, and what the Court of Appeal agreed, was that Morrisons was vicariously liable for Mr. Skelton's conduct. May I summarise our case before developing the points? In relation to vicarious liability, we say that the legal test is whether there is a sufficiently close connection between the wrongful conduct of the employee and what he was employed to do, assessed by reference to job function, time, when did he carry out the relevant acts, geography, where did he carry out the relevant acts, and motive, sufficiently close connection so as to make it just to hold the employer liable. And we will submit that the lower courts arrived at the wrong answer, and they did so because they made four particular errors of law. Their first error was to find that the tortious acts of Mr. Skelton were within the, quote, field of activities, unquote, assigned to him by Morrisons, and in finding, therefore, that there was a sufficiently close connection. We will say that what Mr. Skelton did was not closely connected to his employment responsibilities. On the contrary, he was given access to the data for a specific and limited purpose of supplying it to KPMG for audit by them. He did not have any other task in relation to that data.
I suppose it depends on how you define the field of activity.
That's an important aspect of the case, and we say one has to look at that by reference to all the circumstances, but in particular by reference to when he did what he did, why he did what he did, where he did what he did. All of those factors are of considerable importance. There is...
it's the assignment of the field of activity by Morrison's that is the anterior question. I mean, I can quite understand how you would want to develop arguments that why he did what he did, and when he did it, and where he did it, may touch on the question of the incidence of vicarious liability, but
Yes.
the question of assignment of the field of activity seems to me to be a pretty fundamental one, does it not?
It is fundamental, but it's not the answer to a case, because the question is nevertheless whether, in the light of how one defines field of activities, the wrongful act was sufficiently closely connected to what he was employed to do. So the field of activities cannot determine the case. And to take a trite example, assume that the field of activities of the employee of Morrison's is to work on the meat counter. And the meat counter work requires that the employee is given a very sharp knife in order to carry out his work. But the employee takes that knife home, he secretes it in his holdall, he takes it home and he uses the knife in order to stab his neighbour because of some personal dispute. I mean, no one, in my submission, would seriously suggest that Morrison's is liable, even though the field of activities includes possession of a knife for work activities. So one has to be realistic in my submission about this matter, and there is an evaluative judgment, but the starting point, we say, is that he had no other task in relation to the data. We say the downloading of the data onto his personal USB and the disclosure of it was well outside the scope of his job functions. And I'll show the court, of course, what was said by Lord Torson for the court in Mohammed. And there's a helpful image mentioned by Lord Torson at paragraph 47, and that is whether the employee had taken off his metaphorical uniform at the time when he commits the offending act. And we say that when Mr. Skelton downloaded the data onto his personal USB, and all the more so when he disclosed it months later at home, he had taken off his metaphorical uniform. And I need to develop those points, and I will seek to answer the questions put to me by my Lord Kerr. The second point we want...
Before you move on, when did the causes of action against Mr. Skelton arise? Did they arise when the downloading and the copying took place?
Well, I accept there was a cause of action at the moment when he downloaded. When he downloaded, there was a breach of confidence of the rights of the employees. However, as I will show the court, what the claimants are claiming in respect of is the damage which they say has been caused by the disclosure. The material is very clear on that. And therefore, although there was a tort committed at the time of the downloading, it is not the relevant tort for the purposes of these proceedings and the damages that are claimed. But I accept that had an employee learnt at the moment when Mr. Skelton downloaded onto his personal USB, that individual could, in principle, have sought an injunction and, I suppose, nominal damages. But that's not what they're claiming for. They're claiming for the disclosure. Our case is that neither the downloading nor the disclosure was in the course of employment. The second point that I'm going to seek to develop is we say that the Court of Appeal erred in concluding, it was paragraph 73 to 74, approving the findings of Mr. Justice Langstaff, that there was, quote, an unbroken thread that linked Mr. Skelton's work to the disclosure. What happened was a seamless and continuous sequence of events. That's paragraph 73 to 74, MS pages 186 to 187. As I've indicated in answer to my Lord Lloyd-Jones, it's the disclosure for which the claimants seek damages. We say they need to establish the disclosure had a close connection to the employment. And it doesn't assist them, we say, to contend that the disclosure was linked to the employment in this chain of causation sense. It's not sufficient for the claimants to show that the employment provided the opportunity for the wrongdoing. In any event, all that links Mr. Skelton's conduct to his employment, his conduct of disclosure, is that his criminal plan began at work and was implemented thereafter. We say that far from the criminal plan linking the disclosure to the employment, it serves only to dissociate the disclosure from the employee's field of activities. The third matter I want to develop is we say that the Court of Appeal erred when it concluded that it was irrelevant that Mr. Skelton's motive was to damage his employer's interests. That's paragraph 76 of the Court of Appeal judgment, MS page 187. I accept that the employee's motive cannot assist where there is otherwise a close connection between the employment and the conduct. But the employee's motive can, and here does, throw considerable light on whether the wrongful act was in truth closely connected to his employment. And there's no dispute in this case. It's seen in the sentencing remarks of His Honour Judge Thomas, paragraph 17 of the Statement of Facts and Issues, MS page 65. Mr. Skelton set out to further his personal vendetta against Morrison's and to cause significant loss to Morrison's. We say that is highly material in the circumstances of this case to whether he was acting in the course of employment or was, as we say, using the old-fashioned language, but it's still used in some of the modern cases, whether he was on a frolic of his own. The court may think the word frolic is not helpful. It suggests light-hearted conduct when the circumstances of this type of case habitually involve, for the claimants, pain and suffering, sometimes death. And the concept of a frolic is perhaps not the best concept, but the court understands the nature of the concept, whether the employee is seeking to advance a personal or objective. I will show the court the cases. This is still, and rightly so in our submission, a feature of the modern case law. The fourth point, we say, is the lower courts failed to understand the relevant factors that are applicable to analysis of what Torson in the Mohammed case, paragraph 45, MS page 681, referred to as whether it is right for the employer to be held liable under the principle of social justice. And I'll make some submissions on that point, in particular by reference to the context of processing of data. One of the points against us, of course, is that Morrison's gave Mr. Skelton access to the personal data. But I'll show the court there's legislation, the Data Protection Act, which expressly addresses such an act by an employer who is a data controller. And the legislation, we say advisedly because of the particular features of data, the legislation imposes a specific and limited form of liability which is exclusively fault-based by the employers. And it does so because if, as here, the rogue employee processes data for his own purposes, he is not, the employer is no longer the data controller. There's no dispute about that, as I'll show the court. The data controller is the rogue employee who is using the data for his personal purposes, and that is why the legislation restricts the liability of the employer to a primary liability for choosing that employee. Is there a fault? Has the employer failed to have a proper system? Mr. Justice Langstaff rejected all the complaints relating to that. We say all of this is highly material to assessing the justice of imposing a vicarious liability here at common law. If necessary, we go further, and this is the second part of the case, and we say that the statutory regime under the DPA excludes vicarious liability under that Act and at common law. Two other preliminary points that I should mention. First, whether there is vicarious liability is a matter of law. And it's a matter of law based on primary facts. And if authority is needed for that, it's Lord Nichols in Dubai Aluminium. Could I take the court to volume 1 of the authorities, the core authorities? And it's behind tab 7, and it's MS page number 507. Bundle 1, core authorities, volume 1, tab 7, Dubai Aluminium, a case to which I shall, of course, come back, but for present purposes, I simply want to show the court what is said by Lord Nichols, speaking for the appellate committee at MS page 518. It's paragraph 24. And he's dealing with the test of vicarious liability. He says at 24, in these formulations, the phrases may fairly and properly be regarded, can be said, can fairly be regarded, be token of value judgment by the court. The conclusion is a conclusion of law based on primary facts rather than a simple question of fact. So whether there's vicarious liability, and this is a consistent theme of the case law, is a matter of law. We, of course, go further. We say, with respect, the erroneous conclusion reached by the lower courts was the result of specific errors of law in their reasoning. The other preliminary matter is just to remind the court of what it's, of course, very familiar with, which is what was said by Lord Torson speaking for the court in Muhammad, and that's behind tab 13 of the same volume, MS page 665. And after analysis of the case law, to which I will return, the test was stated by Lord Torson at page 693, MS page 681, at paragraphs 44 and 45. MS page 681, paragraphs 44 and 45, where Lord Torson says, speaking for the court, in the simplest terms, the court has to consider two matters. The first question is what functions or field of activities have been entrusted by the employer to the employee, or in everyday language, what was the nature of his job? As been emphasised in several cases, this question must be addressed broadly, and then he gives authority. Secondly, the court must decide whether there was sufficient connection between the position in which he was employed and his wrongful conduct to make it right for the employer to be held liable under the principle of social justice, which goes back to Chief Justice Holt. Now, I should make clear at the outset that we are not taking issue with these general criteria set out by Lord Torson. They must be understood, of course, in the context of that case and in the context of his explanation of the law in the paragraphs that precede and succeed those two statements. Our submission is that Lord Torson was not purporting to overrule the earlier case law, as he says at various points. Our case is that the lower courts, with respect, failed properly to understand and apply these relevant principles. So can I begin, my lady, my lords, with our first submission, which is that the Court of Appeal and Mr. Justice Langstaff misunderstood and misapplied both the field of activity question and the consequential question of whether there was a sufficiently close connection to the wrong doing. And the court has seen the statement of facts and issues. I wasn't proposing to go through that. It sets out, I hope, very clearly what Mr. Skelton's general role was. It explains at MS page 63, paragraphs 6 to 8, in addition to his ordinary day-to-day duties, he was given a specific function delegated to him, the task of collating and transmitting to KPMG, Morrison's then external auditors, the data which KPMG required in order to conduct the audit. And there's no dispute that that data was successfully transferred to KPMG by Mr. Skelton. Paragraph 10 of the Statement of Facts and Issues, page 64, MS page 64, explains that without the knowledge, without the authority of Morrison's, he copied the data onto a personal USB device. He retained that copy even after any official need for the data had ended. 2 and 4 months later, he then took action to disclose that data onto the internet. He did it on a Sunday at his home address in Liverpool, 80 miles from his workplace. He did it using his personal computer equipment, his USB, his laptop, his mobile phone. It wasn't the same data. He'd manipulated it. For example, he'd put the highest earners first. He had gone to considerable lengths to conceal his identity. That's paragraphs 13 to 14 of the Statement of Facts and Issues, MS pages 64 to 65. So those are the undisputed facts. What Mr. Justice Langstaff said, and can I take the court, please, to Appendix Part 1, MS page 279, where Mr. Justice Langstaff describes...
Could you give me the paragraph number? Because the MS numbers aren't on the hard copies.
Oh, I'm sorry about that. Paragraph 180...
I beg your pardon, there will be if I use the core volume instead.
I can give your lordship the number. It's page 116. It's paragraph 186 of the judgment of Mr. Justice Langstaff. It's MS page 279, and at paragraph 186, his lordship says that Mr. Skelton's role in respect of the payroll data was to receive and store it and to disclose it to a third party. That, in essence, was his task, so far as the payroll data went. The fact that he chose to disclose it to others than KPMG was not authorised, but it was nonetheless closely related to what he was tasked to do. That's the judge's finding, and that was endorsed by the Court of Appeal at paragraph 63 of their judgment, MS page 183, paragraph 63 of the Court of Appeal judgment, MS page 183, paragraph 63, the first question posed by Lord Torson was answered in the present case by the judge in his findings, which we regard as plainly correct. And then 185 is a reference to entrustment of Skelton with the payroll data, and at 186, the paragraph I've just read out from Mr. Justice Langstaff. So that's paragraph 63 of the Court of Appeal, MS page 183. Now, we say that that description defines Mr. Skelton's field of activities far too broadly. The true description of Mr. Skelton's employment duties was that he had assigned to him a specific task limited to securely transmitting the payroll data to KPMG and storing it on his encrypted work laptop for a reasonable period of time thereafter to respond to any queries from KPMG. He was not employed to do anything else with this data, far less to take it home and then disclose it to the world at large.
Is it relevant that he would not have had access to this data but for his employment?
It's relevant, but it's not determinative, because otherwise your lordship would be adopting a principle that whenever...
No, I'm just asking that it's relevant. I'm not suggesting that it's determinative.
Well, it's, in my submission, plainly relevant that the reason why Mr. Skelton has access to this data is because his employers have given it to him. They've entrusted it to him for a work-related purpose. It's not something that he has acquired wholly outside the scope of his employment. So I entirely accept that it's relevant. That is a factor that has to be put in the balance in asking what is his field of activity and is what he's done closely connected to it. That's relevant. But one can imagine, I gave the butcher example. To take another example, the data has been given to Mr. Skelton for a work-related purpose. But suppose he downloads the data in order to identify the home address of another employee. And using that information, he goes to the home of that employee. He knows where they live. And he's got a personal grudge against them, something to do with his wife or his children. And he attacks that employee, causes them damage, burns down their house. I mean, it couldn't seriously be suggested in my submission that the fact that the employee was given the data for a work-related purpose is not merely relevant, but is determinative of whether or not the wrongful act was sufficiently connected to the work that he was charged to do. One has to have some degree, in my submission, one has to have some degree of balance, common sense, realism. And all the cases show this. So my answer is yes, but. That's my answer to my Lord Kerr.
I suppose some years ago there was a series of thefts from judges' rooms in the Royal Courts of Justice. And of course that was an employee at the Royal Courts of Justice who was using the pass that he had. Actually, I don't know the gender of the person concerned, but anyway. In order to get into the judges' rooms and commit these thefts. I don't think anybody suggested that the Courts and Tribunals Service was vicariously liable.
But-
Of course,
but
it was a
what-
very silly thing to do because they could track who it was quite easily, but there we go.
Well, Mr. Skelton acted
Yes.
in a very silly way as well,
Yeah.
and that's why he's in prison. But what could have been said by the judges who, or others who suffered the loss was that you, the Royal Courts of Justice, did not have a proper system. You are liable, primarily liable, and that one can easily imagine, in principle, that sort of argument being you are responsible for the loss because you didn't have a proper security system. And as I've said, that type of argument was run in this case, and it failed on all grounds, with one exception relating to deletion of data, which the judge found that there was in principle a breach, but it had nothing to do with the claims by these claimants. So that in our submission is the answer. Now there are at least two wrongful
Well, I
acts.
was wondering, in applying Lord Toulson's reasoning, how would one approach it? Would one say that although the employee is given the security pass that opens all the doors in the building for the purposes of employment, and you'd say that opening those, well, I wonder, you can say that opening those doors wasn't within the field of his activities?
Well, one would say opening the doors for that type of purpose, presumably it was done either when nobody was there or it may have been done in the evening, is not within his field of activities, absolutely not. And even if it was, it's not, his conduct, his or her conduct, is not sufficiently closely connected to what he is charged to do to make it appropriate for there to be liability. And the two questions in my submission, they merge into each other.
No, but the way Lord Toulson puts it, I think the test of sufficiency is a test of social justice,
Yeah.
which seems to be to do with on whom should the loss, who should bear the loss.
And of course, the companion case of Cox, where your lordship gave the judgment, made it very clear indeed that the courts are not in the business of allocating responsibility by reference to deep pockets, or indeed by reference to insurance, and I'll come to that.
Yes.
So field of activities is a starting point, but the real question in our submission is whether or not what has been done is sufficiently closely connected.
Before one gets on to close connection,
Yes.
but am I to understand your criticism of the judge at paragraph 186
Yes.
is that he's failed to recognise that the field of activity, the particular field of activity, was limited both by purpose and time. He held the data for a specific purpose and was only entitled to hold the data for a period of time relating to that purpose.
It's not only time, it's also function. He's holding the data, he's given access to the data for a specific function.
That's what I meant by purpose.
Well, indeed, and I respectfully agree.
Yes.
Yes, indeed. And what Mr. Skelton does, he does two wrongful acts. First of all, he copies the data, and subsequently he discloses the data onto the internet. And it may be important to note that what is claimed in these proceedings are damages which are said to arise from the disclosure, not from the original copying. And can I support that assertion by reference to the Statement of Facts and Issues, MS page 66. Paragraph 18, headed Proceedings Below. And the court will see in line 5, the claims are for alleged distress, anxiety, upset and damage. In response to a request from Morrison's, the claimant's solicitors provided by letter, dated the 10th of November, plotted histories for each of the 10 lead claimants. The court understands there's some 9,000 odd now claimants, but wisely there's lead claimants, explaining the circumstances they consider relevant in relation to quantum. And then the last sentence, no claimant has made any claim for financial loss. Now that letter can be found in part 2 of the appendix at page 362. I have it behind tab 14. I don't know whether the court has tabs, but it's MS page number 362 of part 2 of the appendix. Court should have a supplementary blue volume headed Appendix Part 2. MS page 362. I can see my Lord Lloyd-Jones does not have it. Maybe have we got a clean copy we can hand up of page 362?
Well, we don't have Appendix Part 2.
Some of
it's
the
in,
members of the
I
court
think
do.
I think it may be in
here?
Is it
Have
in
an
this?
appendix, but part 2.
Oh, well, maybe it's in there. I have it in 2 parts.
I don't know.
Does your lordship's copy go up to page 360? MS page 362.
It does for me, but
The appendix volume doesn't have MS numbers, but it has numbers across the middle of the.
198. The numbering at the bottom of the page is 198.
Yes.
Well, in
Yes.
that case, our
Yes, they're all
appendix,
right. We've got
I'm
it all.
following the practice direction
Yep.
faithfully, only
Yes,
to refer
yes.
to MS pages, as I know that is very important. But it's page 198. I
Yep.
think. Does everybody?
You really need to look and see how many of the court are using laptops.
Well, page 198, this is the letter as advertised in paragraph
Yes.
18 of the Statement of Facts and Issues. This is the letter of 10th of November from the Claimants solicitors. We write further to previous correspondence and discussions in relation to the potted histories. The particular relevant circumstances of each may be summarised as follows. And the first is the first of these lead claimants. I won't identify them, I don't think there's any need to. But if the court could just glance down paragraph 2.1, the court will see that what she is upset about, understandably upset about, is disclosure. Line 2, line 4, 6, 8, line 10, disclosure, prior to the disclosure, 3 lines from the bottom of 2.1 in the light of the disclosure, and the final line were disclosed. So it's all about disclosure. And I won't read through all the others because they're exactly the same. And that's what this case is about. They seek damages for disclosure, no doubt, because any damages from the act of copying, the mere act of copying, any damages would be nominal. The fact that Mr. Skelton copied the data onto his own USB, any damages would be nominal, not least because Mr. Skelton already had access to that data in a lawful capacity. So that's the nature of the claim. And we say that even if the court were to conclude, contrary to my submissions, even if the court were to conclude that the act of downloading the data was within the field of activities broadly construed, and I strongly dispute that, we say the position is very clear indeed that the act of disclosing the data, which is what these claimants are complaining about, the act of disclosing the data 2 and 4 months later at home using his own equipment cannot sensibly be said to have been within his field of activities. Far less can it be said to be closely connected with his job functions. Now, we say there is a very clear contrast between this case and Mohammed. And can I take the court back to Mohammed to see what it was all about? It's in Authorities, Volume 1, tab 13, and it's behind, it's at MS page 665. Volume 1 of the Authorities at tab 13. And the court will recall in Mohammed, the claimant had entered Morrison's kiosk at a petrol station. He'd asked if it would be possible to print some documents from his USB stick. And the attendant, employed by Morrison's, had refused the request. He'd used racist, abusive language, and he'd ordered the customer to leave. And the employee then followed the customer and he subjected the customer to 2 serious attacks. Now, we say that it's clear from Lord Towson's judgment that what his lordship was finding for the court in that case was that the employee was purporting to act in connection with his role in the employer's business at the relevant time. And can I show the court what Lord Towson said at paragraph 47? It's MS page number 681. This is Lord Towson for the courts, Volume 1, Tab 13, MS page 681, paragraph 47. In the present case, says Lord Towson, it was Mr. Khan's job, he's the attendant, to attend to customers and to respond to their inquiries. His conduct in answering the claimant's request in a foul-mouthed way, ordering him to leave, was inexcusable, but within the field of activities assigned to him. What happened thereafter was an unbroken sequence of events, and I'll come back to that under my second challenge. It was argued by the respondent, accepted by the judge, there ceased to be any significant connection between Mr. Khan's employment and his behaviour towards the claimant when he came out from behind the counter and followed the claimant onto the forecourt. That's when the assault took place. I disagree for 2 reasons. First, says Lord Towson, I do not consider that it is right to regard him as having metaphorically taken off his uniform the moment he stepped from behind the counter. He was following up on what he had said to the claimant. It was a seamless episode. Secondly, when Mr. Khan followed the claimant back to his car and opened the front passenger door, he again told the claimant in threatening words he was never to come back to the petrol station. This was not something personal between them. It was an order to keep away from the employer's premises, which he reinforced by violence. In giving such an order, he was purporting to act about his employer's business. It was a gross abuse of his position, but it was in connection with the business in which he was employed to serve customers. His employers entrusted him with that position. It's just as between them and the claimant, they should be held responsible for their employees' abuse of it. Then he deals with motive, and I'm going to deal with that separately. We say that the circumstances of this case are fundamentally different. When Mr. Skelton downloaded the data onto his personal USB, he had metaphorically taken off his uniform. He was not acting, he was not purporting to act on behalf of his employer or for the purposes of his employment. The only considerations which were relevant to him, subjectively, or indeed objectively, were personal considerations. There was no out-facing conduct by Mr. Skelton in downloading the data which could in any way suggest to anyone who knew the circumstances that this had anything to do with his employment functions.
I just wonder how useful the metaphor of taking off one's uniform is in all of these cases. It may well have been, I'm sure it was, appropriate in the Mohammed case, but Mr. Khan could hardly be said to be acting on behalf of his employer in perpetrating the assault on Mr. Mohammed, could he?
But that's not what, with respect, that's not what Lord Towson says. What Lord Towson says is that he is purporting to be exercising the function of dealing with customers, which he was employed to do. He did it in a grossly abusive manner, but nevertheless, he was purporting to carry out that which he was employed to do in dealing with customers, whom customer he regarded as a difficult customer. And that's fundamentally different.
It's the ordering off the premises that you see as the out-facing function. That's the...
yes, but it's the assault that is the gravamen of the
well, according
allegation.
to Lord Towson, I've read it because that's how Lord Towson analyses it. And I'm saying to your lordships, I'm not asking your lordships to revisit the facts. I'm simply emphasising that the principle of law that Lord Towson is applying in the Mohammed case is a principle that he, Lord Torson, for the court, regarded as dependent upon the performance at the time of the wrongful act of a function that was part of his employment responsibilities. That's the point I'm making. Now, I will deal with the other case law and whether that can be said of other cases, but I do not accept that there's anything in Muhammad which is inconsistent with our submissions. I say there is a clear contrast between the circumstances, the relevant circumstances of Muhammad and our case. And I say that not just in relation to downloading. I say a fortiori when we look at the circumstances of the disclosure 2-4 months later. I say that the position there is very, very clear indeed. No one could seriously suggest, if the image of taking off your uniform is the right image, no one could seriously suggest that Mr. Skelton was acting with his metaphorical uniform on at that stage. So
would Morrisons have been vicariously liable for Mr. Khan's actions if what he had done is come out from behind the counter, go and open the car door and set about assaulting the visitor? He wasn't actually a customer, he was a visitor in a way.
Yes, visitor, yeah.
Without saying, off you go and don't come back.
No, to take a hypothetical example, supposing that there'd been some previous disagreement between this customer and the employee. They'd had a row, some personal squabble, and this particular customer comes then to the petrol station, and the employee comes out from behind the counter and attacks this individual for...
Well, that's a bit like the facts of another case,
Yes.
the name of which is escaping me.
Yes, Mr. Justice Hildreth's case.
Yes, indeed.
Right.
Indeed. So these cases are fact-dependent, but the crucial principle is that one has to identify a close link between the offending act and the employment. And it's not enough, I'll show the court the case law, it's not enough to show that the employment provided the opportunity to carry out the wrongful act. It has to be a closer connection than that. And the point is further illustrated by Lord Torson's criticism in Muhammad of an earlier case, the case of Keppel Bus Company. If the court would go in tab 13, if the court still has it open, the Muhammad case, if your ladyship and your lordships would go back to paragraphs 33 to 34, which is on MS page 677, the court will see how Lord Torson dealt with this case. Keppel Bus Company, the plaintiffs travelling in a bus when the conductor treated an elderly lady passenger in a high-handed and rude fashion. The plaintiff remonstrated with him. An altercation followed in which each tried to hit the other. They were separated by the passengers. The conductor struck the plaintiff in the eye with his ticket punch, causing loss of sight in the eye. The trial judge in the Singapore Court of Appeal held that the bus company was vicariously liable, but the Privy Council decided otherwise. The board applied the Salmon formula. It held the conductor's conduct could not be described as a wrong mode of performing the work which he was expressly or impliedly authorised to do. He could not be described as maintaining order in the bus. If anyone was keeping order, it was the passengers. The board rejected the argument that his job could be described as managing the bus and that his conduct arose out of his power and duty to do so. The case illustrates again the awkwardness of the Salmon formula when applied to such situations. Looked at more broadly, the bus company selected the conductor for employment. They put him in charge of the passenger area of the bus. He abused the position of authority which his employment gave him. Because he was throwing his weight around as the conductor, the plaintiff objected. Because the conductor objected to what he appeared to regard as interference with the exercise of his authority, he struck the plaintiff in the face. The trial judge summarised it by saying he was in effect telling the plaintiff by his act not to interfere with him in his due performance of his duties. In such circumstances, it was just that the passenger should be able to look to the company for compensation. Now, that shows that Lord Torson disagreed with the Privy Council conclusion, but the reason why he disagreed with the Privy Council was because the offending act was carried out in the purported performance by the employee of his job responsibilities. And nobody, in my submission, could say that about either the downloading or a fortiori the disclosure.
I'm a little difficulty with the assertion that it was in the purported performance of his duties. It can't be, surely, the purported performance of his duties to assault a passenger, which presumably would have been forbidden by his employer.
Well, Lord Torson at letter F quotes with approval the trial judge. He was in effect telling the plaintiff by his act not to interfere with him in his due performance of his duties. It was, of course, a gross abuse of his job responsibilities to act in that way, but nevertheless, what he did was a purported performance of his responsibility to maintain order in the bus. And I've made the point. What Mr. Skelton did...
What the trial judge said precisely is that the conductor was, by his act, telling the plaintiff not to interfere with him in his due performance of his duties. He's not actually saying that he was purporting to act in the performance of his duties.
No, but there's a close connection in that case. This is how Lord Torson is analysing it, a close connection between what he is employed to do and the action that he carried out. I've made the point. It's a matter for the court whether the court thinks it's helpful. Yeah. I say that here there is a stark contrast between anything that Mr. Skelton was employed to do and what he actually did. It's not in the purported performance. It is a complete negation of what he's employed to do.
Yes, going back to paragraph 47, what Lord Torson is saying is the order not to come back was the purported performance. Yes. And that was reinforced by violence.
Absolutely.
So it was one and the same event, really.
Indeed. The court may also gain some assistance from Lord Torson's approval of the approach adopted in the Lister case, the sex abuse case, many sex abuse cases. And those cases pose, as the court knows only too well, real difficulties. But if a court would look in Muhammad at paragraph 46, which is on MS page 681, Lord Torson says that he's not persuaded there's anything wrong with the Lister approach as such. It's been affirmed many times. I do not see that the law would now be improved by a change of vocabulary. And if we look, please, at Lister, which is at tab 6 of the same volume, it starts at MS page 471.
I think what Lord Torson was referring to there was the close connection test.
Indeed.
He was rejecting the submission that acting in a representative capacity would be, that was the alternative test being put forward.
Indeed, I'm grateful to you, Lordship. Lister is at MS page 471. It's tab 6 of the same volume. And the court will recall that the claimants were residents in a boarding house attached to a school, owned and managed by the defendants, and the warden of the boarding house employed by them, without their knowledge, systematically sexually abused the claimants. And the question was whether there was vicarious liability in those circumstances. And Lord Steyn, speaking for the appellate committee at paragraph 4, set out the warden's duties. And his duties, this is MS page 476, his duties were to live in the boarding house. Most days he and his wife were the only members of staff on the premises. He supervised the boys when they were not at school. His duties included making sure the boys went to bed at night, got up in the morning, got to and from school, administered pocket money, organised weekend leave, evening activities. It was intended to be a home for the boys and not an extension of the school environment. And then at paragraph 5, His Lordship set out in the 4th line that the sexual abuse was preceded by grooming, being conduct on the part of the warden to establish control over the appellants, unwarranted gifts, trips alone, undeserved leniency, watching X-rated videos and so forth. And that developed into blatant sexual abuse. And then at paragraph 20, which is the end of paragraph 20, on MS page 483, right, it's page 227 of the report, MS page 483, a letter, under letter C, it becomes possible, says Lord Steyne, to consider the question of vicarious liability on the basis that the employer undertook to care for the boys through the services of the warden, and that there is a very close connection between the torts of the warden and his employment. After all, they were committed in the time and on the premises of the employers, while the warden was also busy caring for the children. And then at paragraph 28, which is on MS page 486, His Lordship refers to the Canadian judgments, to which I'll come, paragraph 27. Then at paragraph 28, His Lordship says that he's satisfied that in the case of the appeals under consideration, the evidence showed the employers entrusted the care of the children to the warden. The question is whether the warden's torts were so closely connected with his employment, it would be fair and just to hold the employers vicariously liable. On the facts of the case, the answer is yes. After all, the sexual abuse was inextricably interwoven with carrying out by the warden of his duties. Matters of degree arise, but the present cases clearly fall on the side of vicarious liability. So that's the test. Whether the wrong is closely connected with the duties of the employee. And I've made my submissions as to this case. In that case, what is central to the finding of vicarious liability is that the warden, when he carries out the abuse, is still performing, albeit in a grossly abusive manner, acts that are closely connected to what he's charged with doing.
Well, I'm sorry, I have a little difficulty with that proposition and relating it to the facts of the present case. I mean, you say what divorces the present case from cases such as Lister is that when he had access to this material, Mr. Skelton plainly used it for a purpose that was not intended, or could not even have been contemplated, presumably, by his employer. But what's the difference between Mr. Lister, the defendant in Lister's case, completely going against what duties he'd been assigned by his employer?
The difference between the two cases is that, as indicated in the passages I have read to the court, the warden has a general responsibility. It is the function of the warden to care for the welfare of these children. And he is carrying out that job duty in the premises at the time when he should be caring for them in a grossly abusive manner. And the gross abuse is closely connected with the job functions because of the all-embracing nature of the functions. That's how Lord Steyne analyses it in the passages that I've read. My submission, which may or may not find favour with your Lordship, but my submission is that the employee in this case has a very limited function in relation to the data. And what he does with it is so far removed from his job responsibilities as not to be closely connected with his job duties. That's the stark contrast.
Could one not say that precisely about the warden?
No, you can't.
This is so far removed from the discharge of his...
You can say that the sexual abuse is obviously far removed from what he's charged to do, of course. But the analysis by Lord Steyn is that the sexual abuse is, in a legal sense, closely connected with the job duties because of the all-embracing nature of the job duties of a warden, and also that the sexual abuse is the consequence of the performance of the job duties in grooming these children.
The grooming is a very important part
Indeed.
of the background to these sex abuse
Indeed.
cases.
And I'm going to show the court, when I come to it in a few moments, I'm going to show the court that Lord Steyn for the appellate committee, and indeed the other members of the appellate committee, find very helpful the Canadian cases, in particular the Canadian case of Jacoby, which is held to fall on the other side of the line. Why? Primarily because the sexual abuse is carried out by someone similar to the warden, but at a time and a place away from the work premises, and that's highly material to the disclosure element of this case. But I say, applying Lord Steyn's approach, even in relation to the copying of the data, this is not closely connected to the job functions, and I support that with the passage in Lord Steyn's speech, which I haven't yet taken the court to, at paragraph 18, which is on MS page 480. And at paragraph 18 on MS page 480, Lord Steyn says a good illustration of the correct approach is provided by Williams and Hempel. Contrary to the instructions of his employers, a driver of a lorry deviated substantially from his route. On the detour, an accident occurred owing to the fault of the driver. The question arose whether the employers of the lorry driver were vicariously liable. In a speech assented to by all the members of the House, Lord Pearce analysed the position as follows. Had the driver in the present case been driving a lorry which was empty or contained nothing of real importance, I think that so substantial a deviation might well have constituted a frolic of his own, that phrase. The presence of passengers, however, whom the servant is charged qua servant to drive to the ultimate destination, makes it impossible at all events, provided they are not all parties to the plan for deviation, to say that the deviation is entirely for the servant's purposes. Their presence and transport is a dominant purpose of the authorised journey, and although they are transported deviously, continues to play an essential part. It was said in argument there must be some limits to that contention, and that one could not hold that if the driver had gone to Inverness, he'd still be acting on his master's business. No doubt there are such limits to the argument as common sense may set on the facts of each case. But when there are passengers whom the servant on his master's behalf has taken aboard for transport to Glasgow, their transport and safety does not cease at a certain stage of the journey to be the master's business or part of his enterprise merely because the servant has for his own purposes chosen some route which is contrary to his instructions. The more dominant are the current obligations of the master's business in connection with the lorry, the less weight is to be attached to disobedient navigational extravagances of the servant. In weighing up, therefore, the question of degree, whether the admittedly substantial deviation of the vehicle with its passengers and baggage was such as to make the lorry's progress a frolic, that phrase of the servant, unconnected with or in substitution for the master's business, the presence of the passengers is a decisive factor against regarding it as a mere frolic of the servant. In the present case, the defenders remained liable in spite of the deviation for their driver's negligence. So far as Lord Pearce was concerned, it was only because the driver had the passengers in the lorry, the authorised passengers, that he was in the course of his employment driving to Inverness. And we say that on the facts of this case, when Mr. Skelton downloaded he was travelling to Inverness for his own purposes. He had no passengers. And I emphasise that Lord Steyn thinks that's a good illustration of the correct approach. So for Lord Steyn, this concept, and I accept it may be difficult to apply on the facts of different cases, and the sex abuse cases are particularly difficult, but the principle is that you have to show a close connection. And a close connection can be negatived where the rogue employee is on a frolic of his own. It's not the only issue, but it's a highly important issue. And that's approved by Lord Steyn, and Lord Torson says that's the right approach.
I think a common feature in the sex abuse cases is what Lord Steyn talks about, the inextricable interweaving of the of a performance of the duties which are properly incumbent on the employee with the abuse of the position that he's then put in, disciplining children, putting them to bed at night, so on and so forth, to commit the tort in a way which is intimately connected with his employment.
Indeed. It's a crucial feature of those very sensitive and difficult cases. But that's how Lord Steyn approaches it. And what may also assist the court is to see that the appellate committee in Lister referred with approval to the decisions of the Supreme Court of Canada, establishing that there is a limit to this principle. One of those cases was the Jacobi case. It was described by Lord Clyde in Lister at paragraph 48. So if we stay in Lister, and if your ladyship have MS page 493, this is the end of paragraph 48 of Lord Clyde's judgment and speech, and I go to it just to identify what Jacobi was about. On the other hand, says Lord Clyde, this is at 237C, on the other hand, in Jacobi, vicarious liability was not established. In that case, the acts, with one minor exception, took place in the employee's home outside working hours. He was someone who worked in a youth club for children, and he sexually abused the children. The employee's home outside working hours, away from the club, which was the principal place of employment, that the club had provided an opportunity to establish a friendship with the children, did not constitute a sufficient connection. These two decisions, there's Basley, which was the other way, because the abuse was carried out in the care home, or in the club, these two decisions seem to be consistent with the traditional approach recognised in this country. And Lord Steyn himself referred to those cases with approval. If the court would turn back to MS page 486, paragraph 27 of Lister, where Lord Steyn says that he's been greatly assisted by the luminous, illuminating judgments of the Canadian Supreme Court in both Basley and Jacobi. And Lord Millett is to like effect, paragraph 70. And if we go, I'll come back to Jacobi when I come to the unbroken thread point, but for present purposes I'm relying on Jacobi as approved by the appellate committee as a good example of how distance in time and place are relevant to whether the wrongful acts were either within the field of employment or closely connected. The sex abuse there being carried out away from the workplace, which of course is true of the disclosure in this case. And Lord Torson in Muhammad, if we go back to Muhammad, explained what he understood Lister to decide. If we go back to Muhammad, which was volume 1 of the authorities, tab 13, if we go back to paragraph 39, which is MS page 679, paragraph 39 sets out Lord Torson's explanation of Lister, and I won't read it all, but he emphasises just above F that the employers were vicariously liable because they undertook the care of the children through the warden, and he abused them. There was a close connection between his employment and his tortious acts, etc., etc. In Muhammad, Lord Torson also referred, and it's paragraphs 41 and 42, to another decision of the appellate committee, that's Dubai Aluminium, which postdated Lister. And Lord Torson does not disapprove of Dubai Aluminium, a case concerned with vicarious liability when a partner in a solicitor's firm is engaged in a conspiracy to defraud. And can I invite the court's attention to Dubai Aluminium, which is in the same volume at tab number 7. It begins at MS page 507. And the court may wish to note in Lord Nichols' speech, Lord Nichols, the late Lord Nichols, speaking for the appellate committee, at MS page 519, paragraph 26 of Lord Nichols' speech, helpfully notes, realistically notes, a lack of precision in the legal principle. This lack of precision is inevitable given the infinite range of circumstances where the issue, that's vicarious liability, arises. The crucial feature or features either producing or negativing vicarious liability vary widely from one case or type of case to the next. Essentially, the court makes an evaluative judgment in each case having regard to all the circumstances and, importantly, having regard also to the assistance provided by previous court decisions. So there's no algorithm, there's no magic solution that one can provide. At paragraph 27, his lordship, letter D, says he leaves aside cases where a firm or employer undertakes a responsibility to a third party and then entrusts the discharge of that responsibility to the dishonest partner or agent, and he refers to the Morris and Martin case. This is a distinct category of cases where the employer takes on a specific duty of care to a person which is non-delegable. And this court has considered that issue at least twice. My Lord the Deputy President gave judgment for the court in a case called Armes and Nottinghamshire County Council, which my Lord recalls. It's not in the bundles, but it's 2018, appeal cases 355, in particular paragraph 51. And my Lord for the court referred with approval to an earlier judgment of Lord Sumption for the court in Woodland and Swimming Teachers Association, again not in the bundles, 2014, appeal cases 537, paragraph 7. And we're not concerned in this case with such principles, and so I say no more about them. Paragraph 28, Lord Nichols also left aside cases where the wrong party is defrauded by an employee acting within the scope of his apparent authority, and the classic instance, as his lordship says, is Lloyd and Grace Smith. The critical feature in this type of case is that the wronged person acted in reliance on the ostensible authority of the employee. The clerk purports to be acting for the employer and gets the old lady to sign the document handing over her property. Again, we're not concerned with that. And at 29, what Lord Nichols says is he can put aside those cases. At paragraph 32, we come to something that's more relevant in my submission to our type of case. This is MS page 520. he's referred to a broad principle of risk. A distinction is to be drawn between cases such as Hamlin, where the employee was engaged, however misguidedly, in furthering his employer's business, and cases where the employee is engaged solely in pursuing his own interests on a frolic of his own, that phrase again, in the language of the time-honoured catchphrase. In the former type of case, the employee, while seeking to promote his employer's interests, does an act of a kind he's authorised to do, then it may well be appropriate to attribute responsibility for his act to the employer, even though the manner of performance was not authorised or indeed was prohibited. And that's Mohammed. And it is also, in my submission, Lister. The matter stands differently when the employee is engaged only in furthering his own interests as distinct from those of his employer. Then he, and he quotes Justice Isaacs in the High Court of Australia a long time ago, 100 years ago, then he acts as to be in effect a stranger in relation to his employer with respect to the act he has committed, or he's taken off his metaphorical uniform, if the court prefers. Then the mere fact that the act was of a kind the employee was authorised to do will not of itself fasten liability on the employer. In the absence of holding out and reliance, there is no reason in principle why it should, nor would this accord with authority. To attribute vicarious liability to the employer in such a case of dishonesty would be contrary to the familiar line of driver cases, see Lord Pearce's case that I referred to a few moments ago, where an employer has been held not liable for the negligent driving of an employee who was employed as a driver, but at the time of the accident was engaged in driving his employer's vehicle on a frolic of his own. And then there's a reference to Lord Wilberforce, always an authority of considerable importance, in the Kooragang investments case in the Privy Council in 1982. Lord Wilberforce drew this distinction with his accustomed lucidity and authority. He rejected the broad proposition that as long as the employee is doing acts of the same kind as those it is within his authority to do, the employer is liable and he's not entitled to show the employee had no authority to do them. Lord Wilberforce said the underlying principle remains that a servant, even while performing acts of the class which he was authorised or employed to do, may so clearly depart from the scope of his employment that the master will not be liable for his wrongful acts. And we say that is this case. And it's the same principle repeated again and again in the case law, which Lord Torson is either approving or he's certainly not disapproving. We say all of that remains good law. It is supported by Lord Staines's analysis and his approval of Lord Pearce. It's supported by Lord Nichols and his approval of Lord Wilberforce, and it's approved by Lord Torson, more recently in Mohammed, who cites with approval both Lister and Dubai. And we say those are the relevant principles. Another example is the Warren and Henley's case, which Lord Torson refers to in Mohammed. It's tab 13, MS page 665, and the court will see this case referred to at paragraph 45 on MS page 681. It's a time and place point. It's at 693 letter E, MS page 681, where Lord Torson says, by contrast, this is by contrast with Lister, in Warren and Henley's, this is Justice Hilbery, any misbehaviour by the petrol pump attendant, qua petrol pump attendant, was past history by the time he assaulted the claimant. The claimant had left the scene and the context in which the assault occurred was that he'd returned with the police officer to pursue a complaint against the attendant. So again, there's a limit to how far the principle goes that you, the employer, have appointed this individual. There are many, many cases in my submission that support this approach to field of activities and course of employment. I don't want to weary the court, but let me give just a couple more examples. Irving is quite an interesting case. It's volume 2 of the authorities. It's tab 31, and it's at MS page 1055, Irving and the Post Office. And the short head note summarises what was going on in Irving, volume 2, tab 31, MS page 1055. Mr. and Mrs. Irving, who are black and of Jamaican origin, live next door to a Mr. Edwards, a postman. The Irvings did not get on well with Mr. Edwards because he was a racist. Mr. Edwards' duties included the sorting of mail. He was authorised to write upon letters for the purpose of ensuring they were properly dealt with. However, he was otherwise not allowed to write on mail at all. While sorting the mail, Mr. Edwards saw an envelope addressed to the Irvings, and he wrote a racist message on the back of the envelope. And the question was whether the post office were vicariously liable for what he did. And Lord Justice Fox, speaking for the Court of Appeal, deals with the matter at paragraph 12, which is on MS page 1057. And at paragraph 12, his lordship says the doctrine of vicarious liability is necessary for the reasonable protection of innocent third parties, but out of fairness to employers, limits have to be set to it. That's perhaps more particularly evident in a case such as the present, where the post office is sought to be made liable for the willful wrongdoing of Edwards, which the post office in no way authorised. In my judgment, what Edwards did was an act which cannot be regarded as being merely an unauthorised way of performing the duties for which he was employed, namely to sort and deliver mail. Out of personal malevolence to the addressee, he wrote an offensive message on the envelope. This was not the performance of any duty for which he was employed. His employment provided the opportunity for his misconduct, but the misconduct formed no part of the performance of his duties and was in no way directed to the performance of those duties. It was just a piece of spite on the spur of the moment. He was, of course, authorised for postal purposes to write upon envelopes, but what he wrote and the purpose of what he wrote had no connection with the performance of his duties. And we rely upon that case as of a piece with all that the court have seen. The Court of Appeal in the present case pointed out, it's paragraph 71, MS page 185, that there are cases where the employers have been held vicariously liable for torts committed away from the workplace. And I'm not submitting that the mere fact that the wrongdoing was away from the workplace is determinative. It's highly relevant, but it's not determinative. And the case that is cited is the Bellman case. Perhaps we ought just to look at that. It's volume 1, tab 14. Volume 1, tab 14, Bellman and Northampton recruitment. It's a case on which my friends rely, a recent case, 2018, and it's MS page 685. As I say, the Court of Appeal refer to it as supporting their approach, paragraph 71 of the judgment, MS page 185. And what happened here was that the managing director of a company assaults one of his subordinates during a drinking session at a hotel following the staff Christmas party, always dangerous occasions. And it's as a result, sometimes dangerous occasions, it's as a result of a disagreement about business strategy. And Lady Justice Asplin explains why there was vicarious liability in her judgment at paragraphs 25 through to 27, which is MS page 695, in particular paragraph 25. At paragraph 25, MS page 695, her ladyship says, was the judge right to conclude that there was insufficient connection between Mr. Major's field of activities, he's the managing director, and the assault in the hotel at 3 a.m. In my view, he was not. It seems to me that despite the time and the place, Mr. Major was purporting to act as managing director. He was exercising the very wide remit which had been granted to him. His managerial decision-making having been challenged, he took it upon himself to seek to exercise authority over his subordinate employees. The lecture itself was concerned with the nature and extent of his authority in relation to the business and the exercise of that authority over his fellow employees. He chose to wear the same concept, his metaphorical managing director's hat, and to deliver a lecture to his subordinates. He was purporting to use his position and drove home his managerial authority, with which he'd been entrusted, with the use of blows. Looked at objectively, he was purporting to exercise his authority over his subordinate and was not merely one of a group of drunken revellers whose conversation had turned to work. It seems to Her Ladyship the attack arose out of a misuse of the position entrusted to him. He asserted his authority in the presence of around 50% of the staff. He misused that authority, etc., etc. So I have no quarrel with the proposition that there can be vicarious liability for acts committed away from the workplace. It all depends on whether the work is providing the basis
That's
for...
very like the bus driver case,
Yes,
bus
indeed.
conductor case, isn't
Indeed.
it?
I only mention that case because the Court of Appeal placed reliance.
It's also like what Lord Torsten said in paragraph 47 about reinforcing the order to keep away with violence.
Indeed, my Lord. So all of these cases, obviously there are differences between them. So, I say the theme of the case law, both before Muhammad and including Muhammad, is I say, very, very clear. The task of the court is to look realistically at the field of activities and to ask whether there is a close connection between the wrongful acts and the employment duties. And what, with great respect, the lower courts failed to understand is that Lord Torsten in Muhammad was not intending to bring within the scope of authority acts of an employee which, by reason of their nature, including motive, including geography, including time, are acts in respect of which the employee has metaphorically removed his or her uniform. He's on a frolic of his own. And I say here that there is no connection between the employment duties and the downloading. And I say that with all the more force in relation to the disclosure 2 and 4 months later.
Would you accept, Lord Paddock, that this tour d'horizon of the various authorities illustrates very clearly that there's an evolving jurisprudence here, cases that are contemporaneously found to be vicariously liable would not have been perhaps 50 years ago?
Well, I don't, with great respect, I don't accept that, because Lord Torsten last year, or whenever it was, the year before, is accepting as correctly decided the Dubai case, the Lister case, and in those cases there's an approval of the approach of Lord Wilberforce, Lord Pearce. I mean, obviously there's been a greater willingness, I would accept this, a greater willingness in the courts to impose vicarious liability, but not to the extent that could bring this case within the scope of vicarious liability.
Well, various rubricae have been deployed, like close connection, performance of duty, field of activity, and so on. The examination of those concepts, all, as it seems to me, require value judgments on the part of the court.
I would accept that. I would accept a value judgment is being taken. I'm asking the court, when it takes that value judgment, to reject any suggestion that the fact that the employment gave the opportunity, in the broadest sense, can suffice for the employee's purposes much more than an opportunity is required. And it has been traditionally, and in the cases from the 1970s and 80s and 90s, and still important, to recognise that there needs to be a close connection for vicarious liability to be satisfied, and whether there is a close connection depends in substantial part on a realistic assessment of what this employee was charged to do, a realistic assessment of why he did it, an assessment of when he did it and where he did it, and a recognition that there are cases where, because he is acting on a frolic of his own, it is inappropriate for the employer to be held liable. And that is a constant theme of all the case law. And I don't accept...
It's a question of assembling all these factors.
Yes.
I mean, geographical, temporal, and so on, and reaching a value judgment, which I think you accept. And your submission...
I'm sorry to interrupt you, but,
Yes.
but reaching a value judgment based upon the legal principles, the court, with great respect, is not just deciding what it thinks is right. It's looking at the case law and attempting to identify principles of law that can be found from what your lordship described as this tour d'horizon.
Well, principles perhaps. I just wonder whether there are factors which have been identified by various... I'm not sure that there is a single overarching principle to which one can cleave confidently, because there seem to be a cluster of factors that need to be taken into account. I mean, your submission is that the mere existence of the opportunity will not suffice, and I'm disposed to accept that. But you don't shut down the examination at that stage. You have to take into account all of these factors.
I've accepted that, my lord. I began my submissions by saying to your ladyship and your lordships that the best I can do by way of stating a principle is that there needs to be a sufficiently close connection, having regard to the nature of the job functions, the purpose, the time, the geography, all of these factors, which I've accepted in answer to your lordship's questions.
Right.
They're all relevant.
But I think that we need to be clear in our own minds that there's no hard-edged principle here. You've got to take into account a number of factors which have been identified, and then make a value judgment.
I respectfully agree.
And that partakes, I think, ultimately of a somewhat pragmatic consideration.
I'm sure that comes into it. The court is obviously influenced when it gives judgment by two factors. It's influenced by the circumstances of the individual case, and if I may respectfully say so, it's concerned to recognise that life throws up a wide variety of different circumstances, and it would, with respect, be unwise for the court to be too prescriptive about what the principle actually is, because different circumstances are inevitably going to arise.
Well, I think not only the lack of wisdom of that approach, but also the impossible practical, because of the nature of the exercise, it seems to me it's very, very difficult to come up with a non-alterable prescription. I mean, as the cases demonstrate.
Well, as I've said, I've attempted in general terms. My friend may well be able to do better than that, but that's the principle for which we can contend, and it chimes with what I showed the court from Lord Nichols in the Dubai judgment, who said that these cases throw up such a wide variety of human activity and damage that it would be, with respect, unwise to try to be too prescriptive. But nevertheless, there are themes that I've tried to identify in the case law that I say negative any suggestion that my clients can be liable for the activities of the rogue Mr. Skelton.
The way in which Lord Nichols explains it in Dubai is really reminiscent of the way other judges have explained liability in the law of negligence.
Yes.
That there are certain broad principles, but that ultimately you have to be guided by analogy from decided cases, and if there is no clear analogy, by a sense of what would be a just way of applying the general principles.
Indeed. And I'm not suggesting to your lordships and your ladyship that any of the factors that we are focusing on are of themselves determinative. It's not my case that there can never be vicarious liability because the wrongful act was carried out months later in the employee's home. It's not my case that a malign motive, a personal motive of itself excludes liability in all circumstances, but these are highly relevant factors to the court's assessment of the right answer. Can I turn, I noticed the time, can I turn to the second criticism, this will be much shorter, of the lower courts. We say that the lower courts erred in concluding, approving the findings of Mr. Justice Langstaff, that there was, quote, an unbroken thread. This was a seamless and continuous sequence of events. Can I show the court where the Court of Appeal said that? It's in the judgment at paragraph 73 to 74 of the Court of Appeal, MS 186 to 187. And at 73, paragraph 73 of the Court of Appeal judgment, they're quoting with approval what the judge, Mr. Justice Langstaff, said in answer to my friend Miss Proop's argument, and the court sees in paragraph 73 the quotation from paragraph 184, and it's in the third line. I find rather, this is Mr. Justice Langstaff speaking, I find rather, as Mr. Barnes submitted, there was an unbroken thread that linked his work to the disclosure. What happened was a seamless and continuous sequence of events. And over the page, paragraph 74, the Court of Appeal said the findings of primary fact are not in dispute. The judge's evaluation of them in the opening and closing sentences of the paragraph as constituting a seamless and continuous sequence or unbroken chain of events is one with which we, the Court of Appeal, entirely agree. Now, we say that even if, which we have disputed, the downloading of the data onto Mr. Skelton's personal USB was within his field of activities, was closely connected, despite it being a frolic of his own, his use of the data months later in his home, using his own computer equipment for his own criminal purposes, broke any chain back to the course of employment other than in a purely causal sense. And the appellate committee approved in Lister the Jacobi case in the Canadian Supreme Court, which, as I mentioned, was a case where the employee had carried out the sexual abuse away from the workplace. It's quite illuminating in my submission to look at Jacobi as approved in Lister. It's volume 5 of the authorities, and the court will find it behind tab 64, MS page 1998, 1998. And we see the sorry facts in the head note. It concerned a children's club, a non-profit organisation, and it operated a recreational facility for children. There were particular children there. They were sexually assaulted by one of the club's employees, who was the club's programme director, and his job was to supervise the volunteer staff, to organise recreational activities, occasional outing, encouraged to develop a positive rapport with the children. And then some 5 lines further down, all of the assaults, except one incident, occurred away from the club at the employee's home outside working hours. The court was divided, the Supreme Court of Canada, divided 4-3. The majority judgment is what I rely upon, and it begins at MS 2012 at paragraph 29. This is the majority judgment given by Justice Binney, and I should mention as we go through this on MS page 2013, at the end of paragraph 29, there's a passage that echoes what my Lord the Deputy President said in Cox, 3 lines down on that page, page 86. Much as the court may wish to take advantage of the deeper pockets of the respondent to see the appellants compensated, we have no jurisdiction ex aequo e bono to practice distributive justice. Legal principle and precedents favour the respondents, and we draw that to the court's attention.
Sorry, where did we find that? What
I'm sorry,
paragraph?
my lady. It's on page 86, MS page 2013.
Ah, right. Yes.
Right at the top of the page, line 3, I was reading from. Line 3
you.
down to the end of paragraph 29.
Thank you.
The court emphasised at paragraph 36 the geographic point that I've referred to. Paragraph 36 is page 2015, and the court most relevantly for this part of my submissions dealt with the chain of events argument at page 2035, MS page 2035, and it's paragraph 81 of the judgment, where Justice Binney says, paragraph 81, if it was the law that the provision of opportunity was enough to render the employer liable, and I've made my submissions why it's not, and my Lord Kerr made a comment on that, then the progression from step 1 to step 8, the steps are set out in the preceding paragraph, might be seen as a series of but-for opportunities sufficient to impose liability. But that is not the law. I accept that but for the opportunity created by Griffith's employment at the club, it is unlikely these assaults would have occurred in the way they did. As pointed out by Chief Justice Beverley McLaughlin in Children's Foundation, however, the relevant nexus, if it exists, is between the job-related conduct at step 1 and Griffith's criminal assault at step 8. It is not enough to postulate a series of steps, each of which might not have happened but for the previous steps, whereas here the chain of events constitutes independent initiatives on the part of the employee for his personal gratification. The ultimate misconduct is too remote from the employer's enterprise to justify no-fault liability. Direct liability would attach, of course, if the employer could be found derelict in respect of any of its own responsibilities towards these children. However, this appeal, and its findings in our case, has been argued on the assumption there's no such fault on the part of the employer. So a chain, in my submission, I say that's right in principle, a chain is not enough. And of course you could equally say there's a chain in other cases. The Irving post office case, the victim failed to establish vicarious liability in respect of the acts of the racist postman, even though there's an unbroken chain, it could be said, between the employment and the wrongful act. It adds nothing, in my submission, to speak of such a chain. And it's particularly inappropriate to speak, with respect, to speak of a seamless and continuous series of acts, to use Justice Langstaff's phrase, because the only thing that's seamless and continuous is Mr. Skelton's criminal plan, which commences at work and continues until completed months later. And a criminal plan is the quintessence of independent, frolicsome conduct. Indeed, in Jacobi, as we see, the defendant had a criminal plan which he followed through of abusing the children once he got them elsewhere. The unbroken chain analysis, I say, is also unpersuasive because it suggests something inexorable about the sequence of events. But the act of copying did not lead inevitably to the act of disclosure. Mr. Skelton could at any time between November and January have seen sense. He could have changed his mind and simply destroyed the data. The only reason he didn't was because he had a criminal plan. There's another example of this principle, the limits of vicarious
If you're
liability.
leaving Jacobi, I see that Chief Justice McLaughlin and two of our colleagues
Yes,
dissented.
they did.
And I'm just reading from the head note. Vicarious liability is justified as the club's operation of its business and use of the employee in his employment positively created and materially enhanced the risk of the sexual assaults that took place. I wondered whether you wanted to make any observations about that.
I don't accept that as respect. I don't accept it as the relevant principle because it is tantamount to absolute liability. One can always say that the wrongful acts of the employee are the responsibility, the liability of the employer who has created the risk by employing that person and giving them that task. It could equally be said in the bus driver cases, in the racist individual who works for the post office case. It is imposing liability on the employer, even though it has been found that the employer has not breached any direct liability on it. It's done everything it could reasonably have done, and yet it's being held liable simply because it employed this person and gave him this responsibility. And I with great respect, don't accept that that accords with any of the case law that I have cited. It would be irrelevant to many of the cases and the analysis by Lord Torson and those who went before him if that were the correct principle. The question would be a very simple one. Have you employed someone? Yes. Have you given them a task? Yes. Have they used the opportunity to commit the wrong? Liability is established, and that would be good enough.
I'm not sure that you would actually disagree with anything very much that is said by Chief Justice McLaughlin in her discussion of the factors to be taken into account.
Absolutely.
She's applying exactly the same test as the Mohammed test and taking into account a range of factors. It's just that she reaches a different conclusion.
The disagreement primarily is about how you apply those factors to the particular circumstances.
Yeah.
And your Ladyship's right. And your Ladyship, of course, has also seen that the passage in Justice Binney's judgment for the majority that I referred to as to why the chain of events analysis, which is what I'm dealing with at the moment, is not, with respect, persuasive, founds upon the observations of Chief Justice McLaughlin in another case. That's the authority that he is citing, Justice McLaughlin in Children's Foundation at paragraph 37. Children's Foundation being the companion case to this one. Another example, again I cite it because it shows the limits of the principles. Another Privy Council case, which is in volume 3, tab 36, MS page 1141. It's a Privy Council case, Attorney General of the British Virgin Islands and Hartwell, from 2004. Again, it's Lord Nichols giving the judgment here of the board.
Well, I remember it well.
Indeed, well, I was going to say your ladyship was a member. It must have been one of the earliest cases that your ladyship heard.
I think it was the very first case that I sat on in the Privy Council,
Well,
yes.
Indeed.
Which is why I remember it.
Well, the facts are very memorable as well,
Yes,
of
they
course.
are.
I mean, this is a case, an extraordinary case, where a police officer in the British Virgin Islands has access to a service revolver, and it's kept for police purposes. And what he does is he takes it, he travels to another island in the BVI, and he shoots at a woman who is the mother of his children and the man she was with. He obviously thinks there's some personal infidelity or something of the sort, and the plaintiff is a bystander who's injured. And the question for the board, one of the questions, was whether the government of the BVI, as the employer of this police officer, are vicariously liable for his acts in taking the gun and using it for a wholly unauthorised purpose. And it could be said, well, you've taken the risk, you've employed him, you've given him access to a gun, and you, the employer, you're obviously liable because those facts are sufficient to establish vicarious liability. But that's not the approach of the board, and the board's approach is obviously not. That's the conclusion. If we take up the speech, the advice of Lord Nichols, MS page 1145, paragraph 14, at the bottom of MS page 1145, paragraph 14, the immediate cause of Mr. Hartwell, he's the bystander's injuries, was the deliberate, reckless act of the police officer, Laurent, firing his revolver in the crowded bar. Laurent was consumed by anger and jealousy at the sight of Ms. Lafond in the company with Mr. Van der Poel on the fateful evening. He fired shots at one or other or both of them. This is not a case where a police officer uses a service revolver incompetently or ill-advisedly in furtherance of police duties. He uses a service revolver to which he had access for police purposes in pursuit of his own misguided personal aims. The bystander's claim is that nonetheless the government is liable in law for the consequences of the police officer's wrongful acts. There are many circumstances where one person may be liable for a wrong deliberately committed by another. Foremost among such instances are those giving rise to vicarious liability of an employer for acts done by the employee in the course of his employment. Mr. Hartwell has advanced a case based on the government's vicarious liability as employer for acts done by the police officer. This is not Mr. Hartwell's primary case, but it's convenient to mention it first, because the outcome of this claim is clear-cut. The applicable test is whether the policeman's wrongful use of the gun was so closely connected with acts he was authorised to do that for the purposes of liability of the government as his employer, his wrongful use of it may fairly and properly be regarded as made by him while acting in the ordinary course of his employment. See Lister, see Dubai. The connecting factors relied upon as satisfying this test are that he was a police constable on duty at the time of his shooting, his jurisdiction extended to Virgin Gorda, and that before leaving his post, he had improperly helped himself to the police revolver kept in the substation on that island. These factors fall short of satisfying the applicable test. From first to last, from deciding to leave the island to his use of the firearm in the bar, his activities had nothing whatever to do with any police duties, either actually or ostensibly. He deliberately and consciously abandoned his posts and his duties. He had no duties beyond the island. He put aside his role as a police constable, armed with the police revolver improperly taken. He embarked elsewhere on a personal vendetta of his own, a frolic of his own. We say those are, by analogy, the circumstances of this case, that just as P.C. Laurent had access to a service revolver, which he was charged with responsibilities for using in a proper manner, so Mr. Skelton had access to data, which he had employment functions, responsibilities for dealing with. When Mr. P.C. Laurent takes advantage of that opportunity and that item to go and use it for a wholly improper purpose, away from his work, he is on a frolic of his own. So too Mr. Skelton, when he uses the opportunity provided by the data to use it for his own purposes. That's our case. And
But of course, in that case, the police force were held liable for having let him have access to
Indeed.
primary liability.
Absolutely,
yes.
Absolutely. And we answered those allegations in this case. They were very forcefully put by my friend, and Ms. Proops answered them all, and to the satisfaction of the trial judge. And I cite that case because it could equally well be said there, well, there's an unbroken chain of events. You can trace through the employment, access to the service revolver, and it ends unhappily, but it's an unbroken chain of events. That really isn't good enough in our submission. Now, finally, on this part of the case, Lord Torsten does refer to an unbroken sequence and seamless episode in Muhammad. And if we go back to Muhammad at volume 1, tab number 13, the court will see at paragraph 47, which is MS page 681, on page 6, MS 681, paragraph 47, in the 5th line, and I've read this already, Lord Torsten refers to an unbroken sequence of events. And he also refers to, yes, on the next page, MS 682, in the 5th line, he refers to, quote, a seamless episode. It's important in my submission to understand that that use of language relates to the reasons why Lord Torsten considered that Mr. Khan was acting within his employment when he assaulted the claimant. Lord Torsten is not using the language of seamless episode and unbroken sequence of events to link an act external to the employment into the employment. Rather, Lord Torsten was explaining that the nature of the relationship between the employee Khan and his victim did not change after Khan left the counter. So, unbroken sequence and seamless episode in that case was not the reason why the assault was within the employment. Rather, Lord Torsten is saying that because the assault was within the employment, it was an unbroken sequence and a seamless episode. So it doesn't assist, in my submission, that use of language doesn't assist in the circumstances of this case. We also point out that there is authority that if vicarious liability is to apply, every necessary element of the tort which founds liability must occur in the course of the employment. And it wouldn't be enough for my friends to show that the act of downloading occurred in circumstances where it was closely connected. They've also got to show that the act of disclosure is closely connected. There are two authorities on that I can deal with very, very briefly, if I may. Authorities Volume 1, Tab 5, MS page 456, Credit Lyonnaise. And it's Lord Wolfe speaking for the Appellate Committee. And at page 495, it's MS 465, report 495, Lord Wolfe rejecting Mr. Sumption's argument, says at letter F, the short answer to Mr. Sumption's first argument is before there can be vicarious liability, all the features of the wrong which are necessary to make the employee liable have to have occurred in the course of the employment, otherwise there is no liability. So that's the principle, and that was also said in the Dubai aluminium case, which is at tab number 7, Lord Nichols, at paragraph 39, which appears on MS page 522. Paragraph 39 on MS page 522 quotes with approval what was said by Lord Justice Evans in the Court of Appeal. Vicarious liability is not imposed unless all of the acts or omissions which make the servant personally liable took place within the course of employment. I respectfully consider, says Lord Nichols, this proposition as it stands is ambiguous. The ambiguity would be removed if the proposition were amended to read that vicarious liability is not imposed unless all the acts or omissions which are necessary to make the servant personally liable took place within the course of employment. Now, as I've said already, I've accepted in answer to my Lord Lloyd Jones that there was a tort committed when the data was downloaded. But these claimants are claiming damages for the tort of disclosure, for the act of disclosure. And I say that has to be shown to be committed in the course of employment, to use that phrase. So that's the reasons we give for saying with great respect that the lower courts were wrong in adopting a seamless episode approach. The third error of law of which we complain is that the Court of Appeal concluded it was irrelevant that Mr. Skelton's motive was to damage his employer's interest. And the Court said that, the Court of Appeal said that at paragraph 76 of their judgment, which is MS page 187. Paragraph 76, they refer to MS 187, paragraph 76 of the Court of Appeal. They refer to Lloyd and Grace Smith, they refer to Lister, and they say 4 lines from the end of paragraph 76, but, said Lord Toulson, motive was irrelevant. Despite Miss Proup's submissions, we do not accept, there is an exception to the irrelevance of motive, where the motive is by causing harm to a third party to cause financial or reputational damage to the employer. Well, leaving that aside, that here the motive is to damage the employer, I say it is with respect fundamentally wrong to suggest that the motive of the employee is an irrelevant factor. And the court has seen, from the cases I've cited, a number of examples of how motive is relevant. Sometimes it's very important. And that's the Hartwell case in the British Virgin Islands. It's Lord Wilberforce's analysis as approved by Lord Nichols in Dubai. It's Lord Pierce's case. It's the racist postal worker case. We certainly accept that it's been the law since Lloyd and Grace Smith, 1912, that it is no longer the case that vicarious liability is defeated merely because the employee acted for his own purposes. That I do accept. And before Lloyd and Grace Smith, it either was the law or was thought to be the law that was a complete answer. And Lloyd and Grace Smith moved the law on from that proposition. But that's a different matter from suggesting that motive is irrelevant. Lord Steyn dealt with this in Lister. If we go back to volume 1, tab 6 of the authorities, and if your lordships could look at paragraph 17 of Lord Steyn's judgment, it's MS page number 480, paragraph 17 of Lord Steyn in Lister, and he's dealing with Lloyd and Grace Smith, and he sets out the facts, and between F and G, his lordship says this decision, that's Lloyd and Grace Smith, was a breakthrough. It finally established that vicarious liability is not necessarily defeated if the employee acted for his own benefit. On the other hand, an intense focus on the connection between the nature of the employment and the tort of the employee became necessary. And that's right, that's what it decided. It didn't decide that motive is irrelevant, and if it did, then it's been misunderstood in all of the case law that followed on. There's one case that we've identified in which the employee acts to damage the interests of his own employer, his and her own employer, and vicarious liability is not found for that reason. And it's another Privy Council case. It's General Engineering Services, which is Authorities Volume 3, and it's tab 33, MS page 1063. It's the Privy Council, and the judgment is delivered by Lord Ackner, and it's on behalf of a formidable team, a formidable board, which included Lord Bridge.
Oh, they're always formidable.
They are. Lord Templeman, Lord Oliver, Sir John Stevenson. And
I said yesterday to council that I wasn't going to listen to courts being described as strong courts, because that suggested that there were weak ones as well, and we're not going to have that.
I take the points. I concentrate on what they said. And what they said, they were dealing with a case where there's an industrial dispute. And the firemen, who of course are employed to go and put out fires, they decide they're going to go on a go-slow policy in order to enhance their negotiating position with their employer. And they're then notified of a fire at the plaintiff's business premises, and they travel there slowly. This is the head note, sometimes stopping, because they decided not to arrive at the property until it had been substantially destroyed. If they'd taken the normal time to reach the fire, it could have been extinguished with little loss or damage, whereas as a result of the delay, the building and contents are destroyed. The plaintiff brings an action against the defendant, that's the employer, claiming damages for negligence, breach of statutory duty. And the question is there vicarious liability? And the relevant passage is at page 72, MS page 1066, letter E. Lord Ackner says this: their lordships have no hesitation in agreeing with the unanimous decision of the Court of Appeal upholding that of Justice Malcolm that the members of the fire brigade were not acting in the course of their employment when they, by their conduct, permitted the destruction of the building and its contents. Their unauthorised and wrongful act was so to prolong the time taken by the journey to the scene of the fire as to ensure that they did not arrive in time to extinguish it before the building and its contents were destroyed. Their mode and manner of driving, the slow progression of stopping and starting, was not so connected with the authorised act, that is, driving to the scene of the fire as expeditiously as reasonably possible, as to be a mode of performing that act. For all the practical difference it would have made, they might, after answering the call, just as well have waited in the fire station until they were confident the building and its contents were beyond saving, or having arrived expeditiously, then to have refused to take any action until it was late. Negligence which then would have been asserted, namely the failure to answer the alarm or extinguish the fire, could not have been said to have been so connected with the authorised act, that is, immediately answering the alarm or extinguishing the fire on arrival at the scene, as to be a mode of performing the acts. Here, the unauthorised and wrongful act by the firemen was a wrongful repudiation of an essential obligation of their contract of employment, namely the decision and its implementation not to arrive at the scene of the fire in time to save the building and its contents. This decision was not in furtherance of their employer's business, it was in furtherance of their industrial dispute, designed to bring pressure upon their employers to satisfy their demands by not extinguishing fires until it was too late to save the property. Such conduct was the very negation of carrying out some act authorised by the employer, albeit in a wrongful and unauthorised mode, etc., etc. It's a criminal offence. It's another example, but it's a particularly illuminating example, because there, as here, the wrongful act was designed to damage the interests of their employers. And we do say that that is a factor that the court should take into account in assessing whether it's really right to find that what was done was closely connected to the employment. It would be to enable this rogue employee, at least in part, to achieve his objective of damaging the interests of his employers. So there's much authority for the proposition that motive is, or rather can be, relevant to the issue. The Court of Appeal, as the court has seen, cited Lord Torson as approving the irrelevance of motive. And it may be important just to look at what Lord Torson said. It's Authorities, Volume 1, tab 13, going back again to Muhammad. And the relevant paragraph is paragraph 48 on MS page 682. And it's a short paragraph at paragraph 48. Lord Torson simply says at MS 682, paragraph 48, His Lordship simply says, Mr. Khan's motive is irrelevant. It looks obvious that he was motivated by personal racism rather than a desire to benefit his employer's business, but that is neither here nor there. Our submission is that Lord Torson for this court was not intending to overturn the wealth of authority that motive can be relevant to assessing whether or not the act of the rogue employee was closely connected to his employment. It all depends on the circumstances of the case. What Lord Torson was saying was that in the circumstances of the Muhammad case, in particular, the circumstances that he had set out in the previous paragraph, 47, and which I've read to your ladyship and your lordships, the employee's motive could not of itself take his case outside the scope of employment for vicarious liability purposes, because for the reasons that Lord Torson gave in paragraph 47, there was a close connection between what the employee, Mr. Khan, was charged with doing and what he did. It's as simple as that. And I do submit that if Lord Torson had intended to rule in principle motive is irrelevant, he would have analysed the case law and in my submission would have recognised that any such proposition is simply inconsistent with the previous case law. So I emphasise.
It's a fairly graphic phrase. It was neither here nor there. Your submission is that it was clearly relevant.
Well, on the facts of that case, it was immaterial. And I've accepted...
When you say it was immaterial, my understanding of your submission heretofore has been that it couldn't displace the other factors,
No.
couldn't outweigh the other factors. That doesn't mean that it was immaterial.
Well, I accept your lordship's correction. I've accepted in my opening submissions that if the relevant acts of the employee are, for all other purposes, in all other circumstances, closely connected to what he's charged with doing, the employer is not going to succeed by pointing to the motive of the employee. But the motive can be, depends on the facts of the case, it can be highly material to whether or not what has been done is closely connected to the employment. And in my submission, that's what Lord Torson is saying in that paragraph. He is saying that for the reasons he's given at paragraph 47, this is a clear case where what was done was closely connected with the employment. And it doesn't avail the employer, therefore, to rely on motive. Not that motive in principle cannot be relevant. If that were the proposition of law, then Lord Torson would have needed to look at the earlier authorities and confront them. And if Lord Torson did mean that, and I submit for the reasons I've given he did not, but if he did need that, with the greatest of respect, he was wrong. That's point 3. Point 4 is policy matters, because as the court has seen in Mohammed, paragraph 45, Lord Torson poses the question, is there a sufficient connection to make it right for the employer to be held liable under the principle of social justice? And I've already shown the court's not acting as some distributive mechanism. One needs to look at principle here. And we do emphasise a number of features about this case that we say the court may think relevant in looking at all the circumstances of this case. The first of them is this. In the modern computer age, enterprises, whether they're large businesses or they're small charities or clubs, need to process significant quantities of data to operate effectively. And it's in the public interest, as well as in the interests of their employees, that they do so. It's in the employees' interest because they want to be paid efficiently, speedily, effectively. Secondly, it's true, as I've said, this is true not only of sizable commercial enterprises, it's true of all sorts of bodies, charities, government bodies, clubs, associations, NGOs. That's the second point. It applies to all of them. The third point is that there are important limits on the data controller's ability effectively to safeguard the data against employee misuse. And that's because computerized data is by its very nature readily susceptible to abuse, given its non-physical, intangible properties, and the ease with which those who have access to it can effectively copy it, extract it, misuse it. And this is still the third point, the employer cannot easily seek or effectively seek to deter or control that misuse through monitoring, through surveilling its employees, because any such monitoring or surveillance would involve interference with privacy rights. Mr. Justice Langstaff looked at this in absolving Morrison's of any wrongdoing, primary wrongdoing. If the court would kindly look at the High Court judgment, paragraphs 105, which appears at MS 253. That's MS 253, it's paragraph 105 of Mr. Justice Langstaff. He's setting out some of his findings on primary liability. And just above letter F on that page, Roman 4, he says, his lordship says, with 3,500 employees based at Hillmore House, as was Skelton, the resources which would have to be expended to conduct routine active monitoring of the type I've described would simply be disproportionate, if indeed practicable at all, which I conclude it would not have been. And then at 106, he says, routine monitoring would almost undoubtedly be seen as invasive and would require a justification on an individual basis before it could properly be conducted. And he refers to a Grand Chamber decision of the Strasbourg Court. And at the end, and I won't take time on that, the court can see it, at the end of 107, he says, paragraph 107, he says that Grand Chamber case is thus high authority supporting a view that any attempt to institute surveillance of the intensity suggested by the claimants in the present case would be fraught with the risk of being held unlawful. So there are very considerable limits on what an employer can do to prevent misuse of its data. The fourth point is that by its very nature, any abuse of data by employees may well involve large numbers of victims. The more people you employ, the more people who are on your records, if you're a charity and you have people who donate and you've got their bank details. This is an area that's likely to involve potentially a large number of victims. It's of course possible to envisage cases of wrongful acts by a rogue employee outside the data context which cause damage to a large quantity of persons, but that in judicial experience is a rare phenomenon. The cases that we've seen tend to concern one or a handful of victims. But here, I say, by its very nature, the number of victims are going to be very substantial, or may well be. And therefore, if the employer is held liable for the abuse of the data by the rogue employee, they are at risk of being exposed to enormously burdensome group litigation, with the claims in total out of all proportion to the value of the claim to the individual data subject. And the fifth point is relevant to the court's assessment of the justice of this case, is that data controllers, like my clients, are subject to very significant and financially onerous positive obligations imposed by Parliament. And they're imposed under the DPA, the Data Protection Act, covering their data processing activities. The compliance standards which the DPA imposes are supported by civil remedies, Section 13 damages, criminal offences, Section 55 is a criminal offence, one of the offences of which Mr. Skelton was convicted, and regulatory enforcement by the Information Commissioner. That's Part 5 of the Act. I won't take time on the detail of that. And the court knows that in this case, the High Court found that Morrison's had, so far as relevant to the claim, satisfied all the legal obligations imposed upon it by Parliament under the DPA. It's set out in some detail in the Statement of Facts and Issues, paragraph 20, subparagraphs 1 and 2, which was at MS 66 and 67, and that's based on the findings made by Mr. Justice Langstaff. It's also the case, if it matters, and I simply draw it to the attention of the court, that the regulatory body under the DPA, the Information Commissioner's Office, decided not to take any action against Morrison's arising out of what had happened in this case. In fact, they went further. They actually told the Court of Appeal that they supported our contention that our appeal to the Court of Appeal should be allowed. There's a letter which appears in the appendix, MS 381. It's one of the final, in fact, it is the final document in the appendix. MS page 381 is a letter dated the 8th of May 2018 from the Information Commissioner to the Civil Appeals Office. This was prior to the hearing. The hearing was listed, as the letter says, in October, and this letter was written in May. And the letter says, I act for the Information Commissioner, the regulator for the DPA. The appellant solicitors, that's us, have kindly provided the Commissioner with a copy of the skeleton argument in order to assist the Commissioner in deciding whether or not to apply to intervene in the proceedings as an interested party. Having carefully considered the arguments, the Commissioner is of the view it's unlikely there's anything which she may meaningfully add to the arguments currently before the Court which would assist their Lordships. The Commissioner would nevertheless note that she is in agreement with the position adopted by the appellant for the reasons set out in its skeleton argument. The Commissioner would therefore support the contention that this appeal should be allowed. Now, I'm not suggesting, of course, that it's the Commissioner who decides whether vicarious liability applies, but it is of some relevance that the regulator in this sphere takes that view. The claimants say, it's in their written case, paragraph 60.3, MS page 147, that when the ICO wrote that letter, they'd not yet seen the claimant's skeleton argument in the Court of Appeal, and I'm sure that's right, but of course the ICO had read the High Court judgment, and in any event, the claimant's side had every opportunity to send their skeleton argument to the ICO to persuade them to take a different view, and the ICO did not write again to the Court of Appeal changing their position. So our fifth point is that the existence of all these regulatory civil criminal sanctions should, in our submission, make the court, when it looks at justice, less willing to impose vicarious liability on an employer for the actions of a rogue employee. And I will come slightly more detail to the DPA when I come to the second part of our submissions. We say it's no answer to these points for the claimants to say that we took a risk by placing our trust in Mr. Skelton. It's a point put to me earlier by my Lord Kerr. For the reasons I've given, we say vicarious liability is not absolute liability. There's no principle of English law, and it would be contrary to all the authority I've cited if the fact that we employ someone makes us responsible for what they do, however abusive it is, of the employment duties with which they are charged, whatever their motive, whenever they do it, and wherever they do it. The Court of Appeal then suggested that the concerns that I've expressed, the social justice features, are answered by the possibility of insurance. The Court of Appeal dealt with this in their judgment, paragraph 78, MS page 187. Might just be convenient to complete this point before the short adjournment, lady. If the court goes to paragraph 78 of the judgment, which is MS page 187, paragraph 78, the Court of Appeal say there have been many instances reported in the media in recent years of data breaches on a massive scale caused by either corporate systems failures, in which case the employer is liable, or negligence by individuals acting in the course of their employment. These might, depending on the facts, lead to a large number of claims against the relevant company for potentially ruinous amounts. The solution is to insure against such catastrophes, and employers can likewise insure against losses caused by dishonest or malicious employees. We've not been told what the insurance position is in the present case, and it cannot affect the result. The fact of a defendant being insured is not a reason for imposing liability, but the availability of insurance is a valid answer to the doomsday or Armageddon arguments put forward by Miss Proops on behalf of Morrison's. Well, I would respectfully submit that to describe these points as doomsday or Armageddon is, with respect, unfair. We're drawing attention, as Lord Torson suggested was relevant, to the social justice implications of liability. In relation to insurance, before I address it, Mr. Justice Langstaff was also referred to insurance. It was MS page 281, paragraph 194, MS page 281, paragraph 194 of Mr. Justice Langstaff at letter B, where he says Morrison's is more likely to have the means to compensate the victim than Skelton, and can be expected to have insured against that liability. Well, each of those propositions, with great respect, is wrong in law, and I notice the time, and shall I develop briefly my points on that after lunch?
That's probably sensible, because I have the sense that you're going to complete your submissions within the time allotted to
certainly.
you.
Certainly.
Well within the time.
Well, I hope so. Hope so. The shorter the better is normally a sensible principle.
We couldn't possibly comment. We look forward to hearing from you again at 2:00.